Hello, everybody.
This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Stephan Lopez de Luna. It's case number 2024 CR 119. Richard Paw appears defense counsel. Marianne Shirley on behalf of the state of Kansas. The defendant appears at the Greenwood County Jail Zoom location. This matter comes before the court at this time for further proceedings. Status and possible plea is indicated. What announcement is made at this time?
Your Honor, in 2024 CR 119, Mr. Lopez de Luna is going to enter a no contest plea to count one, that being methamphetamine. Counts 2, 3, and 4 will be dismissed. And we will also have an announcement in 24 CR 167 as well, Your Honor.
All right, what is the announcement in the other case?
The announcement in the other case, 24 CR 167, will be a no contest plea to count one, criminal damage, a level 9 non-person felony. Count 2 would be dismissed.
All right, a no contest plea on count one, criminal damage to property in 2024 CR 167. Regarding 24 CR 119, the no contest plea would be to which count?
Count one, possession of
All
methamphetamine.
right. With all other charges in that case being dismissed, Mr. Paw?
Yes, Your Honor.
Ms. Shirley, has Mr. Paw announced consistently with your understanding as to how these two cases would be handled?
He has, Your Honor.
Mr. Lopez de Luna, do you agree as to what your attorney has announced here this morning?
Yes, Your Honor.
All right, I've got a whole number of questions I need to ask you regarding the taking of a plea of no contest in these cases. If there's something you don't understand, I'll give you additional time with your attorney. If you need that time to confer, let the court know, okay?
Yes, sir.
State your full legal name for the record.
Stephan Lopez de Luna.
How old are you right now?
I'm 19.
What's the highest level of education that you've attained?
12th grade.
Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
No, Your Honor.
Have you ever been adjudged to be mentally ill?
No, Your Honor.
Are you currently under the influence of alcohol or any drug?
No, Your Honor.
Are you currently taking any type of prescription medication?
No, Your Honor.
Are you supposed to be taking mental health meds that you are not currently taking?
I have one mental health med that I'm taking right now, actually, yeah.
Okay, and what is it?
You know what it is? I don't know what it's called.
No, I have no idea. 1 second, I can look.
All right, well, what I'm trying to get to here is whether you feel like that you're impaired in any way as a result of this medication.
No, Your Honor.
Do you believe you have a full understanding then of what's going on here in court?
Yes, Your Honor.
All right. Did you receive a copy of each of these charging documents in these two cases that are pending?
Yes, Your Honor.
Do you understand the nature of the charge of unlawful possession of methamphetamine?
Yes, Your Honor.
Do you understand the nature of the charge of felony criminal damage to property?
Yes, Your Honor.
Do you understand that when you enter a plea of no contest, you're not admitting that you did these things, but you're also not contesting that you be convicted just the same? Do you understand that?
Yes, Your Honor.
And you understand when you enter pleas of no contest, you're giving up any legal defenses that you might have had to these charges?
Yes, I do.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, and that you can present evidence at your trial on your own behalf and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify in your case on your own behalf if you wanted to, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, Your Honor.
You understand that when you enter pleas of no contest, you give up these valuable trial rights?
Yes, I do.
Are you aware that you have a right to a trial by jury and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, Your Honor.
You understand that when you enter pleas of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, Your Honor.
Do you understand that you have a right to appeal a guilty verdict if you have a trial?
Yeah, I understand.
You further understand that you may appeal your sentences after entering pleas of no contest, but generally you may not appeal your judgments of conviction after you enter such pleas.
Yes, Your Honor.
Are you aware of the possible sentences that could be imposed as a result of these no contest pleas that you're attempting to make?
Yes, Your Honor.
Let's go over those. In the 167 case, you're pleading to criminal damage to property. It's a level 9 non-person felony. In the most favorable criminal history category of I, you can receive as little as a 5-month sentence. In the worst criminal history category of A, you can receive up to a 17-month sentence. So the sentencing range is 5 to 17 months, depending on your criminal history. We do not know with certainty today what your criminal history is. That will be researched by the Court Services Department, and based on the outcome of their research as of the date of your sentencing, that determines where you fall along the level 9 line, and then you'll be sentenced accordingly. Do you understand that?
Yes, sir.
You also understand that you could receive up to a $100,000 fine for that offense.
Yes, Your Honor.
The other charge that you're attempting to plead to here is possession of methamphetamine. That's on level 5 of the drug offense grid. In the most favorable criminal history category of I, you could receive as little as a 10-month prison sentence. In the worst criminal history category of A, you could receive up to a 42-month prison sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. I need to point out to you that on that grid, if you have even as much as 1-person felony on your record, you are presumptive prison. Do you understand that?
Yes, Your Honor.
Do you also understand that in the other case, if you have 2 or more person felonies on your record, you'd be presumptive prison in that case?
Yes, Your Honor.
On the drug offense, do you understand that you could receive up to a $100,000 fine for that offense as well?
Yes, Your Honor.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
You also realize, as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, Your Honor.
You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, Your Honor.
You also understand that the Kansas Sentencing Guidelines Act has many special sentencing rules. If any of these special rules apply to you and your situation, do you understand that it could affect your eligibility for probation or otherwise affect your sentence?
I understand, Your Honor.
Have you had an ample opportunity to discuss legal matters like this with Mr. Paw?
Yes, I have, Your Honor.
Want any more time with him privately now before we go further?
I don't need any time, Your Honor.
All right. Are you satisfied with the services and advice given to you by your lawyer?
Yes, I am.
Now, these no contest pleas that you're attempting to make, have they been based upon any threat or promises as to what this court will do in regards to your sentences or any other type of threat or promise?
No, Your Honor.
I need to point out to you that if there are any plea agreements between your counsel and the county attorney's office regarding sentencing recommendations, this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, Your Honor.
So how do you plead to count 1 in case number 2024 CR 167, level 9, non-person felony, criminal damage to property?
No contest, Your Honor.
And how do you plead to count 1 in case number 24 CR 119, unlawful possession of controlled substance methamphetamine, a level 5 drug felony?
No contest as well, Your Honor.
Shirley, if you provide a concise statement of factual basis as to each of these two charges.
In case number 24 CR 119, on or about June 1st of 2024, he was observed operating a motor vehicle at 41 miles an hour in a 30-mile-an-hour zone, pulled into Sonic in Eureka, Kansas. At that time, he was unable to provide a driver's license that was valid. The canine unit walked around the vehicle and alerted based upon the alerts and the training of the officers, the vehicle was in fact searched. And at that time, they found a smoking pipe with methamphetamine, and it tested positive through the KBI for methamphetamine residue. He admitted to smoking earlier in that day. With regard to case number 24 CR 167, while he was incarcerated at the Greenwood County Jail on or about September 10th of 2024, he put paper in the sink drain and clogged the toilet with food. The plugs caused the drains to overflow and flooded the Greenwood County Sheriff's Officer. Flooded the water was running down the walls in the downstairs in the office, saturated the computer system, the sheriff's lobby, the televisions in the sheriff's office, and the new cameras, control cameras. And this was in excess of $1,000, but less than $25,000. And that, of course, was in Greenwood County also.
All right, thank you, Ms. Shirley. All right, Mr. Lopez de Luna.
Yes, Your Honor.
At this time, do you make pleas of no contest and accept conviction for unlawful possession of methamphetamine, a level 5 drug felony in the 119 case?
Yes, Your Honor.
Do you now freely, knowingly, and voluntarily enter a plea of no contest and accept conviction for criminal damage to property, a level 9 non-person felony in the 167 case?
I do, Your Honor.
Pa, do you know of any legal reason why the court shouldn't accept this defendant's plea?
No, Your Honor.
Shirley, are you aware of any such reason?
No, Your Honor.
Mr. Lopez de Luna, are you aware of any legal reason or any other good reason why the court shouldn't accept your pleas here today?
No, Your Honor.
Court will accept the no contest pleas made by the defendant and finds that those pleas are made voluntarily. An understanding of the nature of the charges and the consequences of the pleas and a factual basis for each of the two charges does exist. The court finds the defendant guilty pursuant to acceptance of his no contest pleas and adjudges him therefore convicted of the crimes of criminal damage to property, a level 9 non-person felony in case number 2024 CR 167, and in case number 2024 CR 119, court accepts the plea and finds the defendant guilty of unlawful possession of methamphetamine, a level 5 drug felony. All other charges of these two informations are dismissed pursuant to plea agreement. Court will order pre-sentence reports be generated to accurately determine the defendant's criminal history, and the court will set both of these matters for sentencing. Currently contemplating Thursday, June 5 at 1:15 p.m., Mr. Paul?
Yes, sir. 1:15.
1:15.
I will be there.
Lopez de Luna, court's going to order you to comply with any pre-sentence assessments that may be done. You may have a risk needs assessment. You're likely going to have a substance abuse evaluation as well. Those need to be fully complied with and completed at the earliest possible time so that we don't have to delay your sentencing.
I understand, Your Honor.
1:15 p.m. Thursday, June 5 for further proceedings in the case. But Shirley, are you aware of anything further that needs to be addressed here?
No, Your Honor. Thank you.
Mr. Paw, is there anything further the court needs to address?
Judge, I would like to address bond. Mr. DeLuna is in a unique position. He does have another couple of cases that are in front of Judge Crum. Those are going to be heard, I believe, on May 8th. The part of the plea agreement today was part of a global resolution for the other cases. I do not represent him on those other cases. However, I believe that at sentencing, he should be presumptive probation on these, and he has been in custody since September. What I would ask this court to do is basically modify his bond, and then at his plea in May in front of Judge Crum, if Judge Crum modifies that bond pursuant to a plea, this bond can then go into effect.
All right, Ms. Shirley, do you have any information in your file as to why a $100,000 bond was set in this case initially? That's a very high bond. There was obviously some great risk and anticipated about him showing up, or I don't think that bond would be set that high. Do you know what those factors were?
I do not. I do have the other cases. Basically, the cases that are pending are trafficking in contraband and theft of a vape pen in the jail. There is an additional count of the second occurrence of flooding the jail, and the third case is an aggravated battery, which occurred while he was in custody. But as far as the original, I do not have any information about that, Your Honor.
Judge, I think I can shed some light on that.
Go ahead, Mr. Paw.
Judge, back on July 13th of 2024, he had a $5,000 surety bond. Then subsequently on August 1st of 2024, there was a motion to revoke that bond because he had not returned to his address where he was living in Wichita. And I believe at that point, that's when the $100,000 bond was set. And that initial $5,000 was revoked.
Right. Yeah, he's in cell 1 in North Walk.
Turn myself in as well.
And that is correct. He did, when he found out that his bond was revoked, he did turn himself in almost immediately to the Greenwood County Jail.
Well, the notes in the case management system indicate that in the 119 case, the original bond was set at $15,000 cash or surety. At the next hearing, Mr. Paw, where you were involved, it was reduced to $5,000 cash or surety with an EMD. That bond was eventually revoked. The court will reinstate the $5,000 cash or surety bond in case number 2024 CR 119. The case management system notes would indicate that in the 167 case, and this is the one I was referring to earlier, bond was set at first appearance at $100,000 cash or surety. I don't see any even request to review that bond that's ever been made, or at least a ruling that's ever been made subsequent to that time. What concerns the court is that Mr. Lopez de Luna has picked up new cases while in jail. If he picks up new cases while he's in jail under direct supervision from the sheriff's office, wouldn't he be a risk to the community to turn loose pending sentencing in the case? Mr. Paw?
Judge, his track record isn't the best while he's been in custody, but while he was out on bond, he was not charged with any additional crimes. So I don't know
He
if
just commits his crimes while he's in custody.
Unfortunately, that is the track record, Your Honor.
We'll leave bond where originally set in the case at $100,000 cash or professional surety required. I don't know what kind of criminal history we're going to be dealing with this guy. If Crum's case is resolved, he's going to have multiple felonies, which are going to count against his criminal history at time of sentencing in this case. Now, whether that will make him presumptive prison or not, I don't know, because I don't know the rest of his criminal history, which might count in this case. Plus, he's going to have multiple assessments he's likely to need done. I'm gonna leave the bonds at $5,000 in the one case. Were originally set $100,000 on the other. Pending sentencing in the case set for June 5 at 1:15. Mr. Lopez de Luna, regardless of how much trouble you believe you're in, it's in your best interest to fully comply with these assessments when you're asked to do them. That will facilitate you getting sentenced and perhaps even facilitate you achieving some level of freedom. So we'll see you on June 5th, and we'll check the status of all of your cases at that time.
All right, thank you, Your Honor.
All right. Ms. Shirley, anything else?
Nothing. Thank you, Your Honor.
Mr. Paw?
No, Your Honor, thank you.
The Lopez de Luna matters will currently be in recess. This meeting may be ended for all.
Thank you guys so much for coming out and hanging out with me. I love every single one of you. Be safe, be well, sleep sweet, and much love.